Be ready. Start. The petitioner is justified in raising an objection that respondent number 1 did not follow its own tender conditions, but despite the persistent queries raised by the court, the petitioner is unable to show any prejudice caused to it on account of simultaneous opening of the technical and financial bids. We have also examined the explanation given in the reply filed by respondent number 1, which is duly supported by the affidavit of the joint general manager of respondent number 1. Even otherwise, it is not disputed that the petitioner was L3 and as such would not have been awarded the tender in any case. We may also take note of the fact that since both technical and financial bids were digitally uploaded by the bidders, there was no room for any tampering. Additionally, none of the bids was rejected as being technically unresponsive, which in our view works to the benefit of all bidders and not to their disadvantage. We therefore find no material infirmity in the tendering process. The law is well settled that the court would be slow in interfering in decisions relating to tender matters and the scope of judicial review is restricted. It was held by this court relying on a host of decisions that the decision making process of the employer or owner of the project in accepting or rejecting the bid of a tenderer should not be interfered with. Interference is permissible only if the decision making process is malified or is intended to favor someone. Similarly, the decision should not be interfered with unless the decision is so arbitrary or irrational that the court could say that the decision is one which no responsible authority acting reasonably and in accordance with law could have reached. In other words, the decision making process or the decision should be perverse and not merely faulty or incorrect or erroneous. In other words, a mere disagreement with the decision making process or the decision of the administrative authority is no reason for a constitutional court to interfere. The threshold of malifides, intention to favor someone, or arbitrariness, irrationality, or perversity must be met before the constitutional court interferes with the decision making process or the decision. This court, being the guardian of fundamental rights, is duty bound to interfere when there is arbitrariness, irrationality, malifides, and bias. However, this court, in all the aforesaid decisions, has cautioned time and again that courts should exercise a lot of restraint while exercising their powers of judicial review in contractual or commercial matters. This court is normally loath to interfere in contractual matters unless a clear cut case of arbitrariness or malifides or bias or irrationality is made out. One must remember that today many public sector undertakings compete with the private industry. The contracts entered into between private parties are not subject to scrutiny under writ jurisdiction. No doubt, the bodies which are state within the meaning of Article 12 of the Constitution are bound to act fairly and are amenable to the writ jurisdiction of superior courts, but this discretionary power must be exercised with a great deal of restraint and caution. The courts must realize their limitations and the havoc which needless interference in commercial matters can cause. In contracts involving technical issues, the courts should be even more reluctant because most of us in judges' robes do not have the necessary expertise to adjudicate up on technical issues beyond our domain. As laid down in the judgments cited above, the courts should not use a magnifying glass while scanning the tenders and make every small mistake appear like a big blunder. In fact, the courts must give fair play in the joints to the government and public sector undertakings in matters of contract. Courts must also not interfere where such interference will cause unnecessary loss to the public exchequer. The essence of the law laid down in the judgments referred to above is the exercise of restraint and caution, the need for overwhelming public interest to justify judicial intervention in matters of contract involving the state instrumentalities. The courts should give way to the opinion of the experts unless the decision is totally arbitrary or unreasonable. The court does not sit like a court of appeal over the appropriate authority. The court must realize that the authority floating the tender is the best judge of its requirements, and therefore the court's interference should be minimal. The authority which floats the contract or tender and has authored the tender documents is the best judge as to how the documents have to be interpreted. If two interpretations are possible, then the interpretation of the author must be accepted. The courts will only interfere to prevent arbitrariness, irrationality, bias, malafide, or perversity. With this approach in mind, we shall deal with the present case. In the light of the above discussion, we find no ground to interfere by way of this writ petition. The same is accordingly dismissed. Thank you.